agenda not only has the agenda, but it has a legal review and some other things in it that we need access to. So if you could have that up and available.
Some people did a lot of work to put that together.
Yes, they did.
Commendations to who all did that.
Yeah. So let's see. Amanda, I think we're ready.
Yes, and we are live.
Okay.
So I won't go ahead and, oh, go ahead.
No, please go ahead, Amanda.
I was just going to go ahead and call roll. So Catherine Beischer.
Present.
Dr. Paul Bidding. Rachel Blunk.
Present.
Shelley Lucas Edwards.
Present.
James Ferguson. Judge Hunter.
Here.
Co-Chair Lanier.
I'm here.
Co-Chair Moody.
I see him. Here. Is that it?
Yes, you got it. Thank you, Danny. Bree Newsom Bass. Dr. Palmer.
Present.
Steve Stevenson. Dr. Waters.
Present.
Justice Wichard.
Present.
And Dr. Williams.
Present.
And I believe Steve Stevenson just joined us. Is that right? Steve, are you with us? Well, he is signed in, but maybe he's not connected to his microphone yet. In any case, though, we do have a quorum to move forward.
Thank you so much. We have had quite a time between the last meeting and this one. The world has changed dramatically between our two meetings. The last time we met, we took a moment of silence to honor the life of George Floyd, who was born in Fayetteville, North Carolina, and whose murder put our world into a racial uprising in a moment where we are leaning in increasingly to have conversations about race and systemic racism. I feel that it's also important for us to acknowledge two women who are from the time period of Thomas Ruffin, whose names I think come up too infrequently in our conversations and our reflections, and that is the woman Bridget, who is an enslaved woman who was owned by Ruffin's teacher and who Ruffin tamed in Alamance County, and the enslaved woman Lydia of Edenton, whose abuse and shooting was the inspiration for the State v. Mann decision that is very much a part of our work in this moment. If you all would just join me in a moment of reflection in whatever way that you see fit, I'd like to ask us to begin in that spirit. Thank you. Thank you for allowing me to do that. I will now entertain a motion to approve the minutes from our meeting on June 6th of 2020.
Michelle?
Yes.
I have one question, one thing. It doesn't really matter, but it didn't make sense to me. On
Yes.
page 4 of the minutes,
Yes.
it says I moved the question on the motion.
Yes.
It then says the motion did not pass. But when you look at the vote chart below, it looks like it was 7-1 yes with 3 abstentions. So I couldn't make sense of that. It's not important, except that it's going to look nonsensical, I think, unless there's something I don't understand.
Right, so we had, Amanda, can you help us with that? At that point in the meeting, when we had the 3 abstentions, 1 no vote, and then we had 1, 2, 3, 4, 5, 6, 7. I believe that what we did have a discussion, Justice Richard, that at that point, what was our quorum? What was our vote dictate? I think it was 50% plus 1, which was, is that 8 for us? I just want to make sure that I understand how we ended up with it not passing.
That's correct. The vote needed to take action is 8.
So that's what got us there, Justice Richard.
And why is that?
We discussed that at the very first meeting when we established what was a quorum and what was a yes vote. And that was decided at the first meeting when we first became a commission.
It's not important, so let it go. But anybody looking at these minutes in the future is going to wonder about that.
Well, perhaps we can amend the minutes to include what a passing vote is based on the first meeting. And if we need to revisit that discussion, we can certainly do that.
I think just if Amanda would just put a little note in there explaining why it didn't pass, that would totally satisfy me. It's just the illogical look of it that troubles me.
Yes, I agree. I think a note would be well placed there. Thank you for that observation, Justice Richard.
With that, I would move approval.
Madam Chairman.
Yes, Commissioner Palmer. Yes, please.
I got cut off. I'm a little behind in the conversation. Is he moving the approval of the minutes?
Yes, Dr. Palmer, approval of the minutes has been approved with 1 correction. Would you like to second?
Yes, I just want to be sure where we were.
Yes. Would you like to second?
I second.
Thank you. So we need to take a roll call vote, as was the case at our last meeting. Amanda, would you please help us with that?
Of course. Catherine Beischer.
Yes.
Dr. Paul Bidding. Rachel Blank.
Yes.
Shelley Lucas Edwards.
Yes.
James Ferguson. Judge Hunter.
Yes.
Co-Chair Lanier.
Yes.
Co-Chair Moody.
Co-Chair Moody, we're taking a vote to approve the minutes. Do we have a yes or otherwise vote from you?
Can you hear me now?
Okay. Yes, Danny, we can hear you now.
There you go. This damn machine won't work.
So was that a yes or a no vote?
Yes.
Co-Chair Moody? Okay.
Yes.
Bree Newsom Bass.
Yes.
Dr. Palmer.
Yes, present. Yes.
Okay, thank you, Dr. Palmer. Steve Stevenson, I see your note in the chat that you would like to vote yes, and that you don't have, you can't use your microphone. So I'll put you down as a yes. Dr. Waters?
Yes.
Justice Richard?
Yes.
Dr. Williams?
Yes.
Thank you. And with can vote that that motion passes. The minutes are approved with that correction.
Thank you, Amanda.
You're welcome.
And I know next, Amanda, we have a staff report from you. I know that there are some updates that you have to share with the commission.
Yes, that's right. So as you all probably know from the news, the statue of Thomas Ruffin that was housed at the Court of Appeals has been removed. So to the extent that was going to be a topic of conversation going forward, it's now a moot point. That statue is no longer there. So that's my report on that. At the last meeting, you asked me to look into the status of the portrait of Thomas Ruffin that formerly hung in the Orange County Courthouse. I did that, and I did email you all about that, I believe, but I just wanted to mention it during my staff report as well. That portrait belongs to Orange County, and it is being held in storage. And I believe I emailed you the dimensions of that portrait as well. I don't recall them off the top of my head, but they were, they seem to be consistent with the portraits that the court currently has hanging. And the last thing I wanted to talk to you about was the solicitation of public comment. I mentioned that in my last staff report, and you asked me to move forward with talking to the IT department at the Administrative Office of the Courts to determine what the options were for that. I did talk to our communications director, and she let me know that there are basically two options for setting up a portal by which people can submit comments to the commission. One would be to set up a dedicated email address at which people can just email their comments, either as attachment, for example, a group wanted to send a letter on their letterhead, or just as a comment in the text of an email. The other option would be to create a web form that people would just fill in the information on the web form, and it would get submitted to us in the form of a compiled report. And the only difference there is that people wouldn't need to send something from their own email address. I also discussed with the communications director the possibility of having comments mailed as well, because I know that we had that some commissioners had expressed some concern that folks without internet access wouldn't be able to make comment if everything was web-based. And so we could also just provide a PO box for comments to be sent to if people wanted to use snail mail. And that's no problem at all. The communications team at the AOC would also help us prepare a press release with information about solicitation of public comment, what we want people to comment on, and how they can do it. The comms team at AOC is happy to help us do that. So my recommendation would be to just set up an email address and to allow comments by mail as well. The format in which I would receive the information would be easier to work with if it was emailed rather than using the web form. The content would be the same, but the format of a report that would be generated by a web form would be, it'd be like a large spreadsheet with comments kind of in each cell of the spreadsheet, which would just be really hard to work with. So in terms of simplicity for me, I would prefer the email address, but of course we'll set up whatever you prefer if you all decide that you do want to solicit public comment going forward. That was it for me. Go ahead. I'm sorry.
This is Co-Chair Lanier. is it possible, perhaps while we are in the next phase of business, if you could help us, Amanda, by looking for those exact dimensions of the Orange County rough and portrait? When you said that, to your knowledge, it was comparable to the portrait that's within the Supreme Court, were you saying that the dimensions are comparable to the existing Ruffin portrait or comparable to the other Chief Justice portrait?
Comparable to the other portraits. It's a normal sized
It would
portrait.
not put us back in the same place. Gotcha.
Correct.
Okay.
Now, I mean, and I am just spitballing, but
okay, thank you. I think what I'd like to do now is pause and to see if there are any questions for what we have just heard about the statue, the portrait, and then I think the next phase of business is going to be public comment. Are there questions?
Yeah, what are we going to receive comments on? What subject?
I think that's a great question, Co-Chair Moody. That's something I've been percolating on as well. I'm wondering if we need to if we need to just see if there are any other questions about the statue removal or the other portrait, and then let's really dive into the commentary. But I'm also looking in the chat. It looks like I missed a couple of things. So Commissioner Newsom-Bass, can you hear now? I missed that original message that you said you couldn't hear. Can you hear
Yes.
now?
Yes, I can. Thank you.
Okay. Okay. I'm sorry I missed that. Co-Chair Moody, if you would just allow me to just see, are there any questions about the Orange County portrait or the Court of Appeals statue?
I would just like to make sure of what we heard.
Let's self-identify, please, especially if you're on a call.
Oh, this is Catherine Beischer. I just want to make sure I heard correctly what you said about the dimensions of the courthouse, Orange County Courthouse painting. You said it's about the same size as the general run of the portraits in the Supreme Court building?
Yes, that's what Amanda confirmed. Yes, that's what you heard correctly. Yes.
and I have those dimensions now for you.
Amanda's going to share dimension.
It's 42.5 inches by 50.5 inches. And my understanding is that is the dimension of the portrait framed. So that's inclusive of the frame, which I don't know how ornate the frame is, but 42.5 by 50.5 inches.
And what's the general size of most of the portraits in the Supreme Court building?
That's a great question.
Oh, go ahead, Michelle. I'm sorry.
I was just going to say, I'm wondering if it might be more. I think that's a great question, and I think what another follow-up to that would be what are the dimensions of the existing Ruffin portrait? I think we need probably to answer both of those questions.
Madam Chairman, Palmer.
Yes.
I think the question, I may be wrong, I think the question about hearing input from other sources came up before the motion for the portrait in the Supreme Court came up on the floor. And I think if we solve the motion, we'll erase the need for comments, because the comments were to help us to determine what to do about the portrait and the size and all.
Commissioner Palmer, with respect, Commissioner Palmer, we're not making any decisions. We were just clarifying Amanda's staff report. And if we're following the agenda, the next agenda item is talking about public commentary. So we're actually not moving forward with any decisions at this moment. We're just making sure that everyone is clarified on the staff report.
But the question on the floor is, why do we need comments what is the purpose of it? Mr. Richard just asked, why do we
Danny
need
Moody.
these comments? And I think they
Understood.
arose. Thank you, Brian.
No, I understand. It was Co-Chair Moody who asked that question about what do
Okay.
we plan to ask. Yes, and we are actually just about to get to that agenda item. We were just
But
responding to the staff report at this point.
I'm missing something because I thought we asked staff to help set up the way we receive these inputs.
Not yet.
And
We're not there. We were asking her to determine the possibilities, and she shared with us a few options, but we have not yet made a decision as a commission as to how we're going to proceed. We're not quite there in the agenda yet.
I'm not asking how we're going to receive. The question was, why are we going to receive them?
That's a great question. Do you mind if we hold on that for just a moment, Commissioner Palmer?
Fine.
Thank you.
This is Judge Hunter. I had one question to ask. Is the, and I didn't hear this in the earlier comments, is the Orange County portrait available for use in the Supreme Court?
Thank you, Commissioner Hunter. Amanda, can you speak to that?
I asked Orange County to give us their portrait. I know that that
And
will be.
who actually owns the portrait in Orange County?
My understanding is that Orange County owns the portrait. It's not the court system. It's Orange County. So I would think that in terms of loaning the portrait or giving it to the Supreme Court or anything, that if we wanted to ask them to do that, it would be the Board of County Commissioners we would ask, or that the court would ask.
I'm also seeing in the chat that Steve Stevenson is also wanting to know, based on the staff report, in conversations with Orange County, is that portrait available? So that seems like two commissioners have brought that up. And then Bree Newsom is writing that Orange County wrote to the North Carolina Supreme Court asking that the court remove its own portrait. So, Commissioner Newsom-Bass, can you speak to that a little bit? I'm not sure I'm entirely clear on that. Could you clarify that?
Oh, yeah, sure. I was just making that note. Like, I mean, I think, if we wanted to ask them about that possibility, I think that's totally fine. As I recall, in our last meeting, we talked about some other possibilities about what kind of portrait could replace the one that is currently there of reference, so that it would be comparable to the size of the other portraits. But I was just making the note that Orange County actually, in addition to taking down their own portrait, asked for North Carolina Supreme Court to take down theirs as well. So we are kind of like asking them to do something the opposite of what they have already written to the Supreme Court asking for.
Thank you for that clarification. So yes, it would be an interesting conversation if they're asking us to take down the existing Ruffin portrait. How would they receive this request? But I think that is definitely to be determined. Other questions about I think there's a couple of things that we need to maybe confirm, but I just want to see, are there any other questions about the Orange County portrait?
This is Catherine. I wanted to mention something I read about the Orange County when I read on the web that it is a copy of the one at the University of North Carolina.
Okay, I know that was a concern of yours, Justice Richard, in terms of what the appearance of it.
This is Commissioner Hunter. Is that a copy of the portrait that was in the Dialectic and Philanthropic Society?
That's what it says on the web. Yes, I think so.
I see. Thank you.
It says that on the web. I haven't researched it past that.
All right. Thank you. So we have two possibilities as replacement portraits, which would not involve the expenditure of any costs.
Right. I'm just curious. So let's see. Steve Stevenson is also chiming in here. So we may want to have a motion to request the Orange County Commissioners to donate their smaller portrait. My understanding is they wanted the oversized portrait. I think I'm taking you meant oversized portrait taken down. And so, yes, removed. I understand, Commissioner Stevenson. Commissioner Williams, did you want to chime in here?
Yes, I'm not sure about making a motion to ask about the portraits because we haven't really had a discussion about that yet. A full discussion. I mean, when I think about it, I wonder if we are, if this has to do with a historical record of the Chief Justices. When I think about now and into the future, when I look in that space and I see a lot of portraits, I wonder how many more portraits we could actually fit in that space. And practically, if it's about a historical record, would we also want to think about another strategy like putting up a large plaque where the names of the various Chief Justices got added along the way so that there would be some record of who was actually there, but a plaque that could accommodate more people into the future? I'm also thinking as an art historian and thinking about that space holding portraits. I wonder about conservation issues of the portraits that are there and the way that the space is used and what that impact has on portraits, painted portraits, a variety of painted portraits. And mostly, I don't think that Thomas Ruffin deserves any portrait in that space. I think that when I think about his most significant contributions, the personal ones being sadism and cruelty, and then advancing the legal work on behalf of that and the advocacy of that, I don't think he deserves a portrait any place in that space.
Thank you for your candor and clarity, Commissioner Williams. I do think where we are, I agree that we're too, I don't think we're at a place where we need to take a motion on asking for it, but I am wondering, and I don't think this takes a motion, I think we can ask Amanda to seek more information. And I don't think that that takes a motion, just because I think that I agree with Commissioner Williams. We need to have more conversation about what's next for us in our work.
May I say something?
But I don't think we have all the information yet.
I think in a way we've kind of gotten ahead of ourselves here, because I think that one of the main topics we're looking at is what to do with the big portrait. And then once we come up with a recommendation about what we think should be recommended to do with the big portrait, then perhaps would be a chance to consider what else to do after that.
Thank you, Commissioner Beischer. I'd like to pause for a moment and also see if there are there any questions about the statue at the Court of Appeals, and maybe there are none. Just wondering if there are any questions. Okay, we have no questions about the Court of Appeals statute. In terms of, I'm sorry, did someone chime in?
Madam Chair,
Yes.
I think when you get to discussion of the proposed motion, this will sort out. We added a provision to what we've already approved last time regarding the Orange County portrait. And what we decide to do with that will sort of answer these questions. If that is the same portrait or a copy of the portrait that's at the DAFI, the only advantage of getting that would be if Orange County would make a gift of it. Whereas the DIFI is willing to loan it for up to 5 years to be both displayed and copied. So I think maybe if you would skip on to the next item, this would sort out.
So we are kind of into a decision-making moment. So what that would mean, just to make sure we're all clear, is we would now be looking at Commissioner Wichard's proposed motion, and then and have discussion around that. And then we would need to discuss what we would be asking of our constituents, of the public, around commentary. We have heard from Amanda as our staff support that email is going to be the best way for her to receive that commentary, and maybe also snail mail, for lack of a better phrase. And so I'm fine. It looks like Bree's lost audio, but Bree, Commissioner Newsom-Bass, can you still hear us though? I'm wondering if she can still hear us. So I know we're having some technical challenges. So we'll try to bear with each other with this COVID-19 moment that we're living in. Oh, okay, she's back. Thank you, Commissioner Newsom-Bass. I'm fine with moving. It sounds like we are wanting to get into a discussion around what we want to do. I do want to acknowledge what Commissioner Beischer has said, that in some ways there may be another way of looking at this to separate the two decisions. One is we have made a motion to take it down, and now, you know, we're thinking about now what? What does that mean? And so
those are really two separate things.
Well, we did take a vote last meeting that the large portrait would be removed.
We did? But that was intertwined with replacing it with a normal sized portrait. At that point, right. And so, Commissioner Beischer, Amanda, can you read that motion for everyone? The motion to remove and replace with a smaller size portrait.
Sorry, Co-Chair Lanier, you were asking me to read the motion from last meeting that that passed conditionally.
Yes, thank you. That's exactly what I think we need right now.
Okay, give me just one moment to pull that up.
Okay, thank you.
it's the next to the last item in the minutes, Amanda.
Thank you. Yes. Let's see. Oh, I'm sorry. I thought I had it, and then turned out I did not. Okay. Let's see. The proposed motion by Justice Wichard.
It's on.
So
do we have a page?
Unfortunately, the pages aren't numbered, but I think I found it. So Justice Wichard moved to adopt the proposed motion that he had handed out prior to the meeting, with the understanding that revisions would be made to include language addressing the funding of the replica portrait and a blanket condemnation of racism in the courts past. So that's what the commission voted on.
And then the proposed motion, just to be clear, particularly for those who are watching at home, the proposed motion does ask for the removal of the portrait that is currently hanging, but it would replace the current portrait with the seal of the court and commission, or and we're now discussing, or potentially receive a replica of an existing Ruffin portrait. So that motion did carry, and so Commissioner Beischer and Commissioner Williams, I just want to make sure we take a moment to hear from you. That was the motion that passed at our last meeting.
Yeah,
I'm not sure.
this is Catherine Beischer. The thing I wasn't quite clear about is whether there an actual motion to remove the big portrait and do et cetera actually was moved and passed. There was a conditionality about it that I was a little unclear about.
It was the motion was to replace the large. The motion was to replace the large Ruffin portrait with the seal of the Supreme Court.
Okay.
And the condition was to then have a smaller portrait placed in the court. So it was a kind of two-part motion. It did carry.
Okay.
Who, Madam Chairman Palmer, who would second that motion?
You did, Doctor.
All right. Did I also ask to defer the motion to this meeting?
No, it carried.
Yep. But there was a deference because of the discussion of the addition.
You actually, Commissioner Palmer, you did ask to postpone further discussion about the Ruffin statue. The statue that was at the Court of Appeals, and that was seconded by Commissioner Stevenson, and now that statue is no longer there. So that was what you asked to defer.
What was deferred for this meeting?
The conversation about the statue that was at the Court of Appeals, that was what was deferred, and it is no longer, it's a moot point now because the statue is no longer there.
Okay, I have not raised a concern about the statue. My concern and my second last week was about the portrait in the Supreme Court hall. And there was a deference on the discussion because, and I think Mr. Richards would agree, because it asked for some clarification about the racial conversation about the fixed portrait and the size. And I think Mr. Richards prepared additional information for this meeting for that motion. Am I wrong, Mr. Richards?
Dr. Palmer, the motion to adopt what we had passed unanimously, but with the understanding that there would be an addition to it, suggesting that the court might want to give a blanket condemnation of racism. Madam Chair, I think maybe we could focus this discussion if I could point out the changes from what we've already approved that are in what's before us now.
Please proceed, that's fine.
You've got in your packet the motion that we passed last time, again, unanimously. And the changes in this are these. Judge Hunter had asked in the second paragraph to have future portraits in the first line changed to future images. I have done that. The other thing that he asked and that the commission voted to add was a statement on the sources of funds. Judge Hunter had suggested recommending to the court that the Supreme Court Historical Society finance it. I picked up on that and put in a provision in the 1, 2, 3, 4, 5th paragraph about the traditional sources of funding, including the Historical Society. The other thing that is added there is the possibility of acquiring the Orange County portrait. This was Amanda's suggestion that we add this, and it simply gives the court an alternative to ask the Orange County Commissioners either to make a gift or also a 5-year loan. If it's the same as the Dafai portrait, it doesn't matter which one you get. But if the court could get a gift of it, obviously that saves some money. And then the statement at the end, beginning, finally, the commission commends, is the statement you asked for on suggesting to the court that it simply, in some way, blanketly condemn the racism in its past history. I started that with a quote from the Cofield case, where the court in its more recent history has spoken in a way I think we would all agree with, and then put a paragraph saying that despite those eloquent and timely words, for much of its history, it's functioned in a society characterized by racial discrimination, and that it might choose in some way to condemn that and commit itself to an inclusive society with no one being discriminated against on the basis of race, and in which everyone without irrational exceptions has opportunity. Those are the new things. With those exceptions, we voted unanimously last time to approve this.
I assume you are motioning to approve these items you're submitting.
That's what's happening, Dr. Palmer, and I would just like to pause here, and I think that it's worth reading out loud because we are we're open, or we're online for the general public. Commissioner Wichard, would you mind if I read the motion, the full motion?
You certainly may.
Okay. Proposed motion for Portraits Commission, that the Portraits Commission recommend to the Supreme Court of North Carolina the following action regarding the portrait of Chief Justice Thomas Ruffin: that the court adopt a rule limiting the size of future images of former Chief Justices and Associate Justices of the court to that of the largest of such portraits in the court's current collection, excepting the portrait of Chief Justice Ruffin. That the court then procure a portrait of Chief Justice Ruffin that conforms to the newly adopted rule relating to portrait size. That the court procure the portrait in one of two ways. First, the court could commission the painting of a new portrait of Chief Justice Ruffin that conforms to the newly adopted rule relating to portrait size. Said portrait to be prepared from the portrait, the Ruffin portrait owned by the Dialectic and Philanthropic Society, University of North Carolina, Chapel Hill, Chapel Hill, North Carolina. The societies have indicated a willingness to loan their Ruffin portrait to the court for a maximum period of 5 years for this purpose. Historically private sources, e.g. the former member of the court, his or her family or law clerk, bar groups, and the North Carolina Supreme Court Historical Society have funded creation of the portrait in the court collection. That tradition should continue, with private funding being sought for the portrait herein recommended. Alternatively, the court could pursue an agreement with the Orange County Board of County Commissioners by which the board gifts or makes a similar 5-year loan of its roughened portrait, which until recently hung in the Orange County Courthouse, to the Supreme Court for display in the Justice Building courtroom. That the new portrait replace the outsized roughened portrait currently in the Justice Building courtroom, and that the extant roughened portrait be placed in storage with the North Carolina Museum of History or the North Carolina Museum of Art, as the court, in consultation with the appropriate officials of these state institutions, deems most appropriate or desirable. That the placement of the new roughened portrait be moved one space to the left when facing it of the locale of the present roughened portrait, and the portrait of Ruffin's successor, Chief Justices, be moved one space to accommodate the new Ruffin portrait, thereby retaining the current chronological sequence of the portrait. That a large replica of the seal of the Supreme Court be prepared and placed in the current locale of the Ruffin portrait, and that the court adopt a rule that henceforth the court seal shall occupy said space, and no portrait of any former Chief Justice shall occupy said space, to the immediate rear of the sitting Chief Justice's seat in the courtroom. Finally, the commission commends to the court its words in State v. Cofield 320 in C 297302-03 1987 Exum and CJ. Article 1, Section 26 of the North Carolina Constitution prohibiting racial discrimination in jury selection does more than protect individuals from unequal treatment. The people of North Carolina have declared in this provision that they will not tolerate the corruption of their juries by racism and similar forms of irrational prejudice. They have recognized that the judicial system of a democratic society must operate even-handedly if it is to command the respect and support of those subject to its jurisdiction. It must also be perceived to operate even-handedly. Racial discrimination in the selection of grand and petite jurors deprives both an aggrieved defendant and other members of his race of the perception that he has received equal treatment at the bar of justice. Such discrimination thereby undermines the judicial process. Justice Mitchell, joined by Justice Witchard, concurred, stating, the intent of the people of North Carolina was to guarantee absolutely unto themselves that in all cases their system of justice would be free of both the reality and the appearance of racism and other forms of discrimination. The court also quoted with approval of the United States Supreme Court opinion in Rose v. Mitchell, 443 U.S. 54561 LED 22, etc. Discrimination on the basis of race, odious in all respects, is especially pernicious in the administration of justice. Such discrimination not only violates our Constitution and the laws enacted under it, but is at war with our basic concepts of democratic society and representative government, quoting Smith v. Texas, etc. These timely and eloquent words notwithstanding, for much of its history, the Supreme Court of North Carolina has functioned in a society characterized by extensive discrimination on the irrational basis of race. It, as an institution, and many of its members in both their juristic and individual capacities have been active participants in the racially discriminatory policies and practices of that society. the court may wish by a method of its choosing to formally condemn and repudiate that aspect of its history and to commit itself and its members to the fullest extent its jurisdiction allows to policies and practices that promote a fully inclusive society in which no one is discriminated against on the basis of an irrational factor such as race, and everyone with no irrational exceptions has opportunity. So that is the full motion. It is quite robust. I'll open up for discussion and questions.
Mr. Palmer again. Mr. Richard, excuse my mispronunciation. Are you adding, motioning this addition to last week's motion?
Dr. Palmer, I am willing to do that when the commission is ready for me to. I suggest maybe leaving it open for discussion first, but I want to repeat the things I have added here, I added in response to what the commission instructed me to do at the last meeting. This is not just me, it's the commission's idea. And
we all agree with what you've done and applaud what you've done just for parliamentary procedure. It was your original motion, and this is the additions that the commission asked you to bring in. I'm asking, are you moving the acceptance of your report for discussion, or do you want me to move the motion?
I'm happy to do it, or to have you do it, Doc.
No, you do it, and I'll second it. And
Madam Chair, I will make the motion to get it before us, and I'm just trying to be careful not to cut off discussion.
No,
Yes, we'll make sure we have time for discussion.
Great.
Okay, we have a motion. Okay, we have a motion by, we have a lot of seconds. Okay, 1 second, everyone.
You had my second when I asked him if he'd make the motion.
Yes, so thank you, Commissioner Beischer. We do have Commissioner Palmer's second, and we do have a motion, and then we will have a question, and we will now open for discussion. So we will take discussion.
This is Chair.
Danny Moody, Commissioner, Co-Chair Moody.
Yes, I was not able to participate at the meeting, but I would like my vote recorded on the record as voting no to all that I have just heard. And when appropriate, I would like to make a statement in regards to why I base my vote.
Thank you, Co-Chair Moody. I think that it's important, Amanda, for the minutes to reflect that due to technical difficulties, Co-Chair Moody was not able to fully participate in our meeting in June. And now that he's been apprised of the motions that have been made, he is expressing his no vote. I also am realizing that I'd like the minutes to reflect that at our meeting in June and today's meeting, we did have a moment of silence for George Floyd and the enslaved women named Lydia and Bridget, if you could make sure the minutes reflect that. And I see some faces showing up. Commissioner Waters, yes. Are you prepared to respond, ask questions or respond?
Yes, Madam Chair, thank you. First of all, I want to thank Justice Richard for the work that he did to put this proposal before us. And I had the opportunity to read through the discussions. I wasn't able to participate in that discussion because I had to leave that meeting early. But I want to just thank him for the work that he did to put this before us. And to say, Madam Chair, that my intention is to vote no on this proposal because, and my reason why is because as I think about the idea that justice is to be blind, that courtroom, I'm glad that we had the opportunity to go into that courtroom and to sit there and meet there. And it's just incumbent upon me just to say, I believe that there should be no portraits in that room whatsoever. And I know that Dr. Palmer probably brought that up as I read through the minutes. And I want to just to go on record with those comments about what that room itself, the courtroom, I feel should be neutral. Having worked in the court system as a probation and parole officer many years ago, I feel the need to stress that justice needs to be blind. And with those portraits there, I think it corrupts that idea in a way. Not so. My vote on this proposal will be no.
Other questions or commentary?
Actually, I have comments too. Judge Witcher, I also want to thank you for this document and for the additions. I'm actually speaking to the original document and the addition. I talked about portraiture a little bit last time. Portraiture can be a lot of different things. I voted yes for the document because I didn't want the large portrait there, but in the large painting there. I do not want any other paintings in that space, as I mentioned earlier. Portraiture can be a lot of different things. I tried to go into that before, but we didn't really have the time to do that. If we're talking about making mention of people to make sure that they are remembered, there are other ways to do that besides imagery. I would suggest that we think about that. The last paragraph, which is a new addition, there's something about that paragraph that feels a little too general for me, because I think that there are specific acts that have been executed by specific judges, such as Thomas Ruffin, that get minimized by a blanket statement. And I feel like, why use general statements when we can use specific names and specific acts, which are actually available in historical records? I'm not too sure that judges work from general information either. To my understanding, judges think about the specifics. So I don't think that last statement, even as it is accurate, it is obscuring a lot of specificities that I think need to be brought forward. A lot of what's happening in the world right now in terms of the protests has to do with specifics, and specifics are available for this. So, additions. Oh, in addition to that,
Are there other?
I forgot, there's one inaccuracy there. It says that the first sentence, these timely and eloquent words, notwithstanding for much of its history, the Supreme Court of the North Carolina has functioned in a society characterized by extensive discrimination on the irrational basis of race. Yes, extensive discrimination, I mean, by a core group of people. Because if you count all of the bodies, all of the people who were assigned to the category as slaves, then you've got an overwhelming population that is not invested in discrimination and on the irrational basis of race. So that's part of why the statement is not quite getting to where it needs to go in terms of the actual specifics that can be pulled from the historical record that exists. Thank you.
Thank you for your commentary, Commissioner Williams. Are there other commissioners that would like to share commentary or questions?
Palmer again. If the young lady feels strong about her concern, I suggest you make a motion to delete the last paragraph and see if you have support for that concern.
Something would need to be replaced there. Or, yeah, I mean, we can't, something needs to happen there that's not that last paragraph. But that remains in the spirit of the last paragraph. But also, there's the piece about portraiture that I strongly disagree with. The way that, in this case, a portrait has to be a painting. So yes, those two components I definitely disagree with.
Thank you, Commissioner Williams. There's a point that we discussed at the last meeting that we really haven't touched on, but it is a part of this legal review that we've all received. Part of the challenge with the legal review, and I know we talked about this last month, is how are we, what are our shared definitions? And it's the challenge that we are facing is how are we in alignment with the current general statute around objects of remembrance. So we did get a legal review on that. And you have that in the materials that Amanda shared, which did say, they use the word probably. It looks like it's probably okay because of the way that portraits are described in that. And they do make a distinction, Commissioner Williams, for that particular general statute in terms of the legalities of removal. They are making the distinction between two-dimensional painted portraits and three-dimensional, what I know you would also refer to as three-dimensional portraits as well. And they are making that distinction in that general statute. And that's part of what I think is hamstringing us a bit on vocabulary is compliance with that particular law. The legal review that is quite significant does it appears that it does give the court jurisdiction over taking portraits down, which is, I think, one reason we haven't talked about it that much. And then it does also say that the Museum of History is to be involved in terms of custodialship and conservation. So I do think those are important points to just share as we continue. But we've heard from several commissioners. Are there?
Madam Chair,
Palmer.
Yes. Palmer. I always am concerned when people in a group are trying to participate in their government that sometimes just the lack of using a little parliamentary procedure cuts them out of their opportunity to participate. So I say to Commissioner Williams again, if you're strongly concerned about that paragraph, if you don't put your motion on the floor, you're going to lose your argument because you don't have a chance to make a change without the motion.
Okay, well, I put a motion up. Thank you, Dr. Palmer. I put a motion to rethink a passage around the historical past of the court and to rethink how we are going to approach the representation of the Supreme Court justices in the court.
Well, Amanda, I'm wondering if you have that. Do we technically have two motions on the floor at this point?
Yeah,
Substitute the motion.
I'm sorry, say that again, Commissioner Palmer.
She's substituting the motion with an amendment.
Okay. I would like to take a moment to read two comments from Commissioner Stevenson, who is not able to be heard via microphone, but has written 2 comments in the chat. And I would like to read those. And Commissioner Stevenson, if there's anything else you would like to add, please feel free. I'm going to read your commentary. So this is again from Commissioner Stevenson. At first comment, I fully support the detailed and carefully written documentation memorializing what I understand was the will of the majority of this commission at that meeting. That is Commissioner Stevenson's response to Justice Wichard's work. And then he also comes in with a second comment that says, I sincerely feel we are experiencing mission creep and exceeding the scope of our commission. There has never been contemplated removal of all portraits, removal of Ruffin entirely, or individual history of any Chief Justices. Considering individuals' acts as both of professionally or personally is beyond our scope. So Commissioner Stevenson believes that it is beyond our scope to entertain the concept of removing all portraits or to entertain the complete removal of any Ruffin portrait. That is his belief, and again, that's from Commissioner Stevenson. Commissioner Moody, Co-Chair Moody, are you wanting to comment at this time?
If it's appropriate at this point in time.
I believe it is. We're all in it together.
All right. I have a statement here I put together because I couldn't comment last time, and I think that some facts need to be brought out based on things I've heard here today. Now, I will say in the beginning that no one has ever heard me blow my own horn or toot my own horn about what I've done or not done and the preservation of the history of the Supreme Court. But I will say this now because I think it's necessary. There is no one who has worked harder to complete the collection of Supreme Court justices than I have. I'm responsible for the presentation of 11 portraits in the collection, either by raising funds necessary to have a portrait painted, encouraging families to present portraits, or in one case, going to a deceased former member's home to receive a portrait, and because of a dispute within the family, the sheriff of the county sent 2 deputy sheriffs along with me for my protection. Due to my efforts, the North Carolina Supreme Court is one of the few courts in the nation which has a complete collection of portraits or former members of their court. Now, the court, as Mr. Wichard is aware, this commission has presented false information. In one of his missives, the lawyer from Chapel Hill says, and I quote, Ruffin wrote hundreds of opinions involving enslaved people. Well, while it is absolutely true that while on the court, Chief Justice Ruffin wrote 1,491 opinions, but the thought and the claim of hundreds of cases was a bit far-fetched, so I did a little research. I examined every case to come before the court from 1819 till 1862, in which a slave was charged with a criminal offense, was found guilty at trial, and the conviction appealed to the Supreme Court. During this period of time, there were 56 cases in this category to come to the court. Out of these cases, I examined the cases in which Chief Justice Ruffin authored the opinion of the court. There were 13. Out of the 56 cases to come before the court from 1819 until 1862, 40% of the cases ruled by the court were in favor of the slave. Out of the opinions of Chief Justice Ruffin, 66% were in favor of the slave. 13 is a far cry from hundreds. There are 4 cases I think the commission should know about because people have brought up other people who were involved in these cases. In the case of State v. Charity, Charity was a slave and she was charged with the murder of her own child. At trial, the master of the slave was ordered by the trial court to testify against his own slave. Charity was convicted and sentenced to be hanged. Ruffin wrote the opinion and noted in his opinion that this was a case of first impression, that no case could be found to support or against the trial judge. Ruffin wrote that a master could not be compelled to testify against his own slave, and the murder conviction was reversed. In State v. Martin, Martin was convicted under the statute which says it is a capital offense, quote, for any person of color to make an assault with intent to commit a rape upon the body of a white woman. Upon the pronouncement of guilty verdict, a motion was made by the defense at trial to arrest the verdict due to the insufficiency of the indictment. The trial court granted the motion. At this time in history, the prosecutor could appeal from the trial court. The prosecutor appealed to the Supreme Court. And Ruffin's opinion, upheld by unanimous court, upheld the trial court in its dismissal of the conviction because the word intent was not in the indictment. The same principle was used in State v. Jesse. In State v. Jarrett, although Chief Justice Ruffin did not write the opinion, he did join in a unanimous court. Jarrett shows how far the court went to assure fair trials for the slave population. Jarrett was convicted of killing an 18-year-old white boy named Thomas Chatham. During a game of cards, a fight developed, and Jarrett hit Chatham in the head with a tree limb, causing his death. Jarrett was tried and convicted and sentenced to be hanged. The court's opinion says if the two combatants were white, one killed in a fight, the charge would simply be manslaughter due to the killing being done in a fit of passion. Ruffin, in agreement with the court, extended this thought to Jarrett. Even though he was a slave, he was still entitled to well-settled principles of law. Two of the most famous slave cases ever to come before any court was State v. Will and State v. Hoover. Hoover was a white man of Iredell County and was charged with the murder of his own slave. To his great surprise, he was convicted at trial and sentenced to be hanged. Hoover appealed to the Supreme Court, and Hoover was so sure of the outcome of the hearing before the Supreme Court, he did not even send counsel to argue his case. Ruffin wrote for the court, for a unanimous court, and upheld the conviction of Hoover, and he was hanged for the murder of his own slave. As far as I know, this is the first time a slave owner was executed for the murder of his own slave. State v. Will. Will was a slave owned by the Battle family of Nash County. During a fight, Will cut the white overseer in the arm, and the overseer bled to death. Will was charged and convicted and sentenced to be hanged. The Battle family appealed to the Supreme Court. The opinion written by Judge William Gaston, joined by Chief Justice Ruffin and Judge Daniel, said a master had authority over a slave and could administer any correction within reason the master thought necessary. But that correction could not reach the life of the slave. The conviction was overturned and Will was returned to Nash County. If you examine the slave cases coming before the court, it will show that the North Carolina court was the most liberal court in the entire South, if not the nation, involving members of the slave population. There is some, I will skip over part of this. It comes from Chatham, Orange County, that the claim is made that Chief Justice Ruffin divided slaves' families. This is true to a point. You look at the cases that come before the court involving estates, you will find evidence that in fact slaves were divided. But you have to look at the law as it was, and in great part is still in effect. The families were divided by operation of law, not because of an individual effort of Chief Justice Ruffin. The example I will use, say a planter had 4 children and 8 slaves. In his will, he leaves to each child 2 slaves. Between the time the will was drawn and the planter's death, 2 of the slaves had 2 children each. The children are not mentioned in the will, but are covered under the residual clause of the will, which states any property not specifically mentioned in the will would be equally divided between the heirs. If the heirs can't reach some agreement, then the 4 slave children must be divided between the heirs. This was and is law. If a will is properly drawn and all legal requirements are met, no judge on his own, regardless of what court he sits on, can change a will. The state is very clear in State v. Mann. The The opinion itself clearly sets out the facts in the case, and they cannot be denied. But it is also a fact that Ruffin was junior member of the court at the time of Mann. No mention has been made about the other two members of the court, who Mann was a unanimous decision. Also, no mention was made at the time that what was going on in North Carolina at the time Mann came down. The population of North Carolina, Virginia, and South Carolina were terrified due to a slave revolt along the Virginia line, and people were scared of being murdered in their own beds. It is clearly stated in the opinion that Ruffin had a great deal of trouble reaching the decision he reached. It is rare that an appellate judge includes such statements in his opinions, but according to the lawyer from Chapel Hill, Ruffin's statements in his opinion should not be believed. A few years ago, this same lawyer and an independent scholar, whatever that is, from Chapel Hill led an effort to have the Ruffin name removed from Ruffin Hall in Chapel Hill, which was fully supported by the law school there. I went to a seminar which was held to discuss Ruffin, and particularly State v. Mann in relation to Ruffin Hall. After the meeting, because I had not paid any attention to State v. Mann, I went to the archives and pulled the file which has the original record in State v. Mann. When I opened the file, on top was the opinion, which was published in the report, and it was reported word for word. Also in the file were two draft opinions. I did not make copies of the different opinions, which was a mistake, but I do remember there being changes made between the drafts and the final opinion. The only assumption that can be made is that during a court conference, the three judges made changes. Although Mann is signed by Ruffin, it's clear to me at least, the final version was the work of the court, not only Chief Justice Ruffin. A few weeks ago, I took another look at the Mann file. Now there is the original published opinion and one other draft. The third draft is now missing. We will never know what that draft said. The other two members of the court were, in fact, both slave owners, and as a matter of interest to myself, I went back in the records that I have and have identified all the members of the court who owned slaves, and even those who fought for the Confederacy. The undisputed facts are, since the Ruffin portrait was presented, there have been 83 judges, including 3 members of this commission, who sat beneath the painting, and not a word about the painting was uttered except to say that Thomas Ruffin was a great judge. I have conducted more tours of the court than any other person, and not one person has ever questioned the painting of Chief Justice Ruffin, except to ask why it was bigger than the others. Part of my duties while I worked at the court was to welcome attorneys and make sure they got the right seat, and not one lawyer said, "I don't think I can argue my case because Thomas Ruffin is looking at me." In fact, in almost 140 years, no complaints were heard until now. A few years ago, Justice Harry Martin read a paper in open court, the court included Mr. Witcher, by the way, concerning the centennial of the presentation of the Ruffin statue. In his address, Justice Martin praised Justice Thomas Ruffin for the great chief judge he was, not a dissent from anybody. In Great American Judges, the well-respected legal historian John R. Weil, after writing an unbiased review of Chief Justice Ruffin, says, and I quote, in 1870, he, Ruffin, advised his son against joining the Ku Klux Klan, believing that the whole proceeding against the law and the civil power of government, and assumes to supersede by taking the power of trying, condemning, and punishing in their own hands. Ultimately, then, Ruffin acknowledged greater allegiance to the law than the Southern system he had tried so long to uphold. I believe that before you pass judgment on any historical figure, you must examine the entirety of his life. As I have told the commission before, if a historical question is brought forward, you start with a question and you work forward examining all information that you can possibly find and reach your answer. This commission has started with the answer and worked backwards, very carefully selecting information it wishes to consider. The ultimate goal has always been to remove the portrait of Chief Justice Ruffin, with totally ignoring others who have served on the court, who have done equal or far worse than what he did. We will ignore Chief Justice R. Hunt Parker, who very vehemently opposed school segregation in his opinions of the court. And even after Brown came down, he was absolutely opposed to it. We will also ignore former Justice Sam Ervin and his opinion of civil rights, that in his book, Preserving the Constitution, he has a chapter, Civil Rights, Civil Wrongs. Chief Justice Thomas Ruffin has been described by Dean Roscoe Pound, former Dean of the Harvard Law School, as one of the 10 eminent jurists, not only in North Carolina, but in the history of the United States. Numerous legal scholars have done a complete examination of the life of Chief Justice Ruffin, and all say, although they point out his flaws, he was one of the greatest legal minds of this nation. Chief Justice Ruffin is one of the very few American jurists who has been quoted with authority at Westminster Hall. Thomas Ruffin donated land on which St. Michael's is built, as well as the land for the burial ground at St. Michael's. And now I suppose the church will have to be torn down and all the people there dug up and moved somewhere else. Thomas Ruffin was the president of the State Agriculture Society, which started the state fair. But that's not to be considered, I don't guess. Mr. Wichard's motion includes the idea that another painting be done or secured in some way of Chief Justice Ruffin and placed where the portrait of Chief Justice Nash is now, and all of the paintings be shifted over one space. During certain renovations of the Justice Building several years ago, all the artwork and as well as everything else in the building was removed, except for the portrait of Chief Justice Ruffin's frame, which could not be removed from the building. The portrait was removed from the frame, and the frame was wrapped and left in the building because it could not be removed. In removing the painting and rehanging them in the current locations, as careful as the movers were, many of the frames hanging in the courtroom and elsewhere were damaged. Given their fragile condition, this could not be helped. The bottom of the carts which they were moved and stored in were covered in parts of the frames which had fallen off or were knocked off. And now, if moving them once again is done, it will further damage these very fragile frames. Each time these portraits are removed, there is tremendous danger of the portraits being damaged or destroyed. The painting of Chief Justice Ruffin is extremely fragile and is in need of restoration, as well as many other paintings that are in the collection. The painting will have to be removed from its frame, and to get it out of the building, the frame itself will have to be taken apart, which probably is going to destroy that painting. Rather than see another painting of Ruffin replace the one that's there, I would rather see the painting, if that's the will of the court and they can get it through the legal system, removed and no portrait hanging anywhere in the building of Chief Justice Ruffin. Leave the statue where it is, wherever it is, never to be seen again. That is preferable to reducing Chief Justice Thomas Ruffin to the dusty heap of history. I know without a doubt that I'm beating my head against a stone wall because this commission has already said we must take the portrait down regardless of whatever. But I will thank the commission for doing this for me. For the last several years, I have tried to make the determination what to do of a collection I have at home. For the past 30 years, I have been collecting every scrap of information I could find about the court and those who have served as judges and justices. In my collection, I have the two oldest law licenses issued by the court, one to the inferior court, another to the superior court, both issued to John Gray Bynum and signed by Chief Justice Richmond Pearson, William Battle, and Edward Reed. And these are the two known earliest licenses issued by the court. I have the only book known to have been part of the library of the first Chief Justice, John Lewis Taylor, and it is signed by him in 3 places and was gifted to the Chief Justice by the Solicitor General in 1787. I have books from the first Judge Rodman's library as well as books from the Library of Chief Justice Richmond Pearson. I have a vast collection of photographs of the court and various members of the court, which includes a photograph of Chief Justice Joseph Branch on his first day in practice. I have the only known photograph of the court sitting in the Supreme Court building, which is now the Labor Building, with Chief Justice Walter Clark as Chief Justice. And I have the only known photograph of I. Waverly Lake Sr. issuing the oath of office to Chief Justice Susie Sharp. Through the years, I have compiled extensive biographies of former members of the court. As far as I know, these are most informative biographies of the former members of the court, and I've even examined their genealogies. As a matter of interest, the great nephew of Chief Justice Richmond Pearson was Tennessee Williams, probably the greatest playwright in the United States history. The grandson of Chief Justice Leonard Henderson married Margaret Howell Davis, who was the president of Jefferson Davis. Chief Justice Leonard Henderson's father, Judge Richard Henderson, started the Transylvania Company, and the Transylvania Company sent Daniel Boone on his explorations. And the son of the first Judge Connor was the first archivist in the United States. In addition, I continued the work by Raymond Mason Taylor. Several decades ago, Raymond began an inventory of all the paintings and artwork in the collection of the court. I made a copy of what he had compiled and had added information as each portrait was presented. This volume includes the name of the artist, size of the painting, size of the frame, where the presentation address can be found, date of the presentation, the military service of each member, what schools he attended, other public offices held by each member, any civic organizations, and a compilation of biographical references each member. It's my understanding the original copy has disappeared, so my copy is the only copy in existence. Most of my collection is housed in the Secretary bookcase, which was built by Thomas Day, who was a black cabinet maker who made furniture for the state capitol as well as part of the woodwork in the governor's mansion, and who, by the way, also owned slaves. But I've reached the determination upon my death, these materials will be burned to avoid someone coming along and either revamping or destroying part of my work. I have talked about the removal of the rough-in painting with several former members of the court, as well as numerous taxpayers. And without exception, all say, well, what fool came up with that idea? And in closing, let me say that I'm terribly, terribly glad that Dr. H.G. Jones, Professor William Powell, and the distinguished historian, Dr. Jerry Cashin, are all dead now, so they will not see this travesty of history. Thank you.
Madam Chairman.
Commissioner Palmer, please hold. We have some comments in the chat that I need to read. From Commissioner Stevenson, we had at 2:19 p.m., he wrote, in the simplest of terms, the majority of this commission has previously determined to replace the large portrait with the Supreme Court seal, North Carolina seal, a smaller portrait to be a similar size of the majority of portraits to be placed to the left of center of the dais. And then a recommendation to the court that future portraits be limited to the average size, which is his statement is in harmony with Commissioner Wichard's motion. And next, Commissioner Bree Newsom-Bass has asked to comment next. And I am looking at the chat. I know that not everyone is on it, but if there are people who need to comment in the chat or ask to be recognized next, I can acknowledge you that way, and then you will also hear from folks who are on the phone as well. Commissioner Newsom-Bass, you are being recognized.
Thank you. Yes, I just wanted to share my reaction and, to the whole discussion. First of all, I do appreciate the work and the effort that Mr. Wichard put into crafting the document that is there right now, or the motion as it exists right now. I do think that it can serve at the very least as a good template for what a final, kind of motion or presentation recommendation could be presented to the court, just in terms of how it is outlined. And my understanding too, kind of based on our last meeting, was that was what we asked him to do. So I do thank him for that. My reaction is kind of back to a question I remember asking, I think, at one of our earliest meetings, which is, is it necessary for the commission to be in complete agreement about what is recommended? Like, are we only able to make one recommendation, or can we share, a series of recommendations? Can we share just what came up from the commission, even if everyone is not in agreement on that? And the reason that I ask that is because I personally would be fine with both options that have been presented, either the one that is written in the motion right now, which is to take down the large portrait and put a smaller portrait there, which is in, alignment with all the others that are already on display. I would also be in support of taking all of the portraits down, because I think that what has come up in the discussion today is also very valid about the need for blind justice. And so to have a courtroom where the only thing that is, now you could put the portrait somewhere else, I mean, that's another discussion, but just specifically about the courtroom, the seal of the state of North Carolina is about the only truly neutral thing. And in addition to that, I mean, I think that Co-Chair Moody's statement actually just demonstrates exactly why it is urgent to take the Ruffin portrait down. And potentially, I mean, on the other side of that statement, I'm actually more in favor of taking all of the portraits down after Co-Chair Moody lifted up other justices who may have, problematic histories, for that very reason, because it's not neutral. And it shows how the presence of the Ruffin portrait represents a century or more of slavery apologia, of historical revisionism, and this way of elevating certain figures in a way that is really ahistorical, right? So this idea that Ruffin should be venerated because of his ruling, because his rulings were in some cases less severe towards enslaved people than others, or portraying him as a man of his times, that is classic historical revisionism and slavery apologia. The fact is that people from the beginning, even before we had a United States of America, from the time that North Carolina was a colony, you had people arguing against slavery in the courts. We could make the argument that if we were going to put portraits up to anyone, that we would lift up those figures. The fact that the people who held the most power, who controlled the courts, were the ones who were often arguing were not just arguing in favor of slavery, but were slaveholders themselves, is just a demonstration of how the court itself has been a primary instrument in maintaining white supremacy and slavery. I mean, again, this comes back to the central issue of why people are calling for the portrait to be taken down. The argument that it has not been an issue until now, again, is a false historical revisionism. What has happened is that we have had centuries of people like myself, who look like me, the people that I am descended from, being engaged in a prolonged struggle for human rights and equality in this land. I am descended from people who were enslaved in Virginia and North Carolina and South Carolina. Were it not for the people who constantly resisted and fought against people like Ruffin, I would still be enslaved today. And so the presence of the portrait is representative of not only the white supremacist ideology that Ruffin represented and that the court has represented for so long, but it's also representative of this ongoing historical revisionism and making constant apologies for slavery and racism, while we are still very much engaged in an ongoing struggle to actually achieve this idea that, Richard, when he made reference to, what was it, the court ruling about juries, right? And having at least the appearance of not being discriminatory, right? We're still engaged in that struggle. That is not something that we have realized yet. So this is not a struggle that is behind us. It's not like we are at a point where we can say for certain that the Supreme Court of North Carolina and all of its, subsidiaries are neutral, that they no longer discriminate against people. We know that's not the case because we are still embroiled in ongoing legal battles for voting rights and voting access. And so to cite any time period prior to today and the opinions of the people who were in control of the systems and the courts and the powers prior to today as having any kind of relevance, right? For how we should understand these events now, again, is why the presence of the portrait is problematic. Because in that argument, what you are doing is erasing the existence of all of Ruffin's contemporaries who were actual abolitionists, who were constantly making the arguments in the courts and in other avenues against the enslavement of people, period. The idea that because, in a particular case, he was less harsh on enslaved people than some others would have been, that makes him a person of reverence. I completely disagree with and am frankly very offended by that notion. I think that there are other contemporaries that deserve much greater veneration. And it just, again, highlights the fact that the veneration of Ruffin as a figure is specifically because he is a symbol of the Confederacy. He is a symbol of white supremacy. Again, we have to go back to the very first meeting when we were presented with the historical material about when this portrait was first commissioned. This portrait was commissioned in the aftermath of the Civil War because they wanted portraits that were comparable to the portraits of George Washington and the figures of the American Revolution. They wanted figures of their heroes who were not heroes of the Union, but were specifically figures of the Confederacy and of the slaveocracy and the slaveholding society. So, I mean, again, I think that what we have here is as far as emotion, like I think this is a good starting point. I agree. I think that we could craft the language in the last paragraph a bit more. And I actually kind of want to apologize a bit because as I recall at that last meeting, we had made mention of us kind of contributing to that process of helping Richard kind of craft that language. And I know I didn't really participate in that, but if we wanted to have some kind of process where maybe we could offer up some language, for a final paragraph or something like that, I think that would be great. I think the basic outline of the document that's there is a great starting point. However, but yeah, on the other side of this discussion, I mean, like I said, I think that getting a smaller portrait and moving it is a reasonable compromise between those who do not want to move the portrait at all and those who want to take all of the portraits down. But I think that the discussion that has come up and what has come up in Co-Chair Moody's statement is just a stronger justification for taking all of the portraits down from the courtroom space and only having the state seal of North Carolina, because that's the only truly neutral thing that you can place in that space.
Thank
Madam
you.
Chair, Madam Chair.
Yes.
This
yes,
is
Commissioner Waters.
Yes, if I could just make a statement and in many ways echo what Commissioner Bass just said. If anything, I want to first let me thank Co-Chair Moody for the extensive research that he did to put that together. If anything, to me, it really reiterates to us again how complicated and complex our history is. And I would say that it further supports the idea of the need of neutrality in that particular room, that space as a courtroom, a place where we are trying to get towards justice, which is supposed to be blind. I would also say that we need to be reminded here as well that enslaved people were denied their liberty in a nation that was supposed to have been birthed out of the idea of liberty for all. That's what we said we were supposed to be. This is what we have been working for, and we see that at work in the conversations that are happening now. And I would also say that while Ruffin may have from time to time found in favor as co-chair Moody stressed in ways that were in favor of the enslaved. Each time he found in favor of an enslaved person, he still condemned them to a life of imprisonment and slavery that denied them their liberty. And so I think that we have to remember that. So thank you, Madam Chair.
Madam Chair, this is Judge Hunter.
Madam Chair,
Judge,
what position did you put me in when you recognized me earlier?
I'm so sorry, Commissioner Palmer. You're right. I did recognize you. Commissioner Palmer, if you would please share your commentary, and then Commissioner Hunter, I will ask you to speak next, and then after that, I have another comment to share from Commissioner Stevenson, who's typing in the chat. Commissioner Palmer.
Madam Chair, I was listening to Mr. Moody's rationale, and I thought for a while he was speaking in favor of the motion. I supported the motion because I thought we started from a compromised position. But Mr. Moody made a couple of comments that just about changed my mind. He said, one, that he collected and established all of this history for the court, and I commend him on an excellent job. But in so doing, he evaluated why Justice Ruffin was of the size it was, but he didn't say they evaluated all justices on their contribution to determine the size of the portrait. So I had to leave his argument out on that score. But then he turned around in his latter statement and said he recently had an attorney that stood in that courtroom and said he cannot make a justice statement with all these judges looking at him while he was in the courtroom, which suggests...
Correction, Commissioner Palmer, Commissioner Moody said that he has never heard someone say that.
No. He specifically said that he had a lawyer that was
Co-Chair
in court.
Moody? Co-Chair
Am
Moody,
I
are you
unmuted?
on? Yes, you're unmuted. Could you please clarify?
Statement was that part of my duties at the court was to help lawyers get in the right seat on the right side of the courtroom. And I have never heard an attorney say that I cannot argue my case because I'm being looked at by Thomas Ruffin. The words were never, I did not say that the lawyer said he couldn't do it. Mr. Palmer, you just got the back end of it.
I apologize. Point being, that argument is valid, that lawyers trying to argue a case, looking at a large stature of a judge over the presiding judge's head, should prove difficult for them to argue a case in their best interest. Nonetheless, young man made a comment earlier that we should consider moving all the portraits out of that room. We were never given the opportunity to say there was space available to move these portraits out of the courtroom into another setting. If that had been made, that would have been my preference. And if it is available, my preference, instead of shaving the courtroom of size and position, that we ought to move all the portraits out of the courtroom so it can remain a center of law and justice, and then argue about the size of the portraits. Other than that, if it's a compromise, I still hold to the motion on the floor, and I ask Mr. Richard, in your written statement, would you consider where you say henceforth the court shall occupy space and no portrait of any former Chief Justice. Now, I ask you, are you going to leave out only former and not say successor Chief Justices, meaning those are to come? Is that space never to be occupied by a portrait or just former portraits of Chief Justices? That was my only question about this item I've seconded. Did you mean to include Chief Justices in the future, or are you only referring to past or former Chief Justice?
Justice Richard, are you still with us? One second, Commissioner Palmer. Are you still with us, Justice Richard?
I am here. Are you hearing me?
We hear you fine.
Yes.
Okay. Dr. Palmer, no portrait is hung until the person is a former Chief Justice. There are no portraits at the court of people who are still serving.
Okay, but my question is, are you putting a blackout on just former Chief Justices, or are you saying no future Chief Justices portrait can occupy that space?
I think this is a generic term covering all such portraits, simply because no portrait goes there until the person has left the court, either without the ability to return or without the intention to return. So it is only portraits of former Chief Justices that go up. So this absolutely covers any future portraits, yes, to answer your question.
I won't debate your terminology. But if there's room, Madam Chairman, and I'll shut up, for these portraits to be moved to another site, I certainly will be one to support that action of this commission.
Okay, thank you. Thank you, Commissioner Palmer. Yes?
Madam Chairman, this is Judge Hunter. I think I was next.
You are next, and then after you, I will read Steve Stevenson's commentary.
Well, why don't you read his commentary first, because I'm going to conclude by asking. I mean, we've got 6 minutes left in the 2 hours that we agreed to meet, I think, today. And I want to vote on, I think we've already passed Justice Wickard's motion unanimously. And I guess my only question is, if we've adopted his motion unanimously, won't that be our report to the Supreme Court? And then if people want to write letters to the Supreme Court, in addition to that, expressing their views on this subject, I certainly think that members of the commission those views ought to be appended to what I call the lowest common denominator. But, you know, I enjoy historical discussions, and I certainly enjoy hearing the views of everyone here on the commission, and I learn a lot when I hear everybody's different views. But I think we have to come up with what I call the lowest common denominator that we can all agree on to make a recommendation, or we have to say that our views are just so compelling to us that we can't come to a commission and end this project one way or the other. I mean, we've met a good bit of time, and I just think we need to move on with, with our lives and try to come to some conclusion. I think Justice Wickard's compromise is about the best we're going to do and get the requisite majority of members under our rules. So that's really what I want to say. I'd like to get I don't know if we need another vote, but if we do need another vote, let's take whatever vote we need to take and move along.
Okay, I'm going to read Commissioner Stevenson. He says, please add, in my opinion, we cannot judge any legal actions of the justices at the time of their service. The judges are charged with carrying out the law in effect at the time. Revision of history, oh goodness, it's sliding away. Revision of history is judging historic actions by today's standards. We're sliding down a slippery slope, and the conversation is sliding away from our commission's charge. Commissioner Newsom-Batts responded, but we are judging the legal actions by choosing to venerate Ruffin, and also says ending the veneration of individual justices is the only true neutrality. And I'm still not clear if unanimous agreement on recommendation is necessary, which I think Commissioner Newsom-Batts is echoing what we've just heard as a potential possibility for what Judge Hunter has just said. So I would like to remind you of what my answer was when Commissioner Newsom-Batts asked the first time, do we have to have a singular statement? So I'll remind you of a precedent that is relevant. When the Secretary of the Department of Administration, Michelle Sanders, came to the North Carolina Historical Commission to ask for the removal of Confederate monuments on state capitol grounds as a public safety issue. Of course, this was before the George Floyd uprisings and the recent removal of these monuments. There was a committee, a working group that was put together to study this matter. And that group was made up of North Carolina historical commissioners that had a variety of opinions on the matter. And they were collegial, but not unanimous and not single-minded. And so they did put forth individual opinions. There were motions. There was a motion, that was passed at that time to not remove it based on the general statute around objects of remembrance. And of course, we now know where we are today in terms of the public safety aspect. What was, I think, useful to note about that moment is that there were individual perspectives that were then shared for both the public and the commission, and on behalf of the of that commission. So I think that we do have a motion. It does seem like we have some acknowledgement that there can be some work done to that last paragraph. We've heard an amendment brought up to the motion from Commissioner Williams. We've also heard other folks who've said, I think that I could support that motion with that language being continuously worked on, and that there needs to be, I think, an opportunity for individual expression around some other possibilities, including the removal of all portraits from the courtroom. There were a couple of things I wanted to say in terms of Co-Chair Moody. I want to put on my fellow commissioner hat. I too want to thank both Commissioner Moody and Commissioner Wichert for their work. And Commissioner Moody, I don't, as a museum professional, like the idea of your materials being burned up, because I know that they are valuable, but I do understand your passion and your perspective. There were a couple of points of clarity that I did want to share for the commission as well as for those listening in. It was actually St. Matthew's Episcopal Church in Hillsborough that Chief Justice Ruffin donated the land for. He was very much connected to another slave-owning family that was also part of that congregation, the Cameron Benahan family, that owned the largest plantation in North Carolina, as well as with the Western expansion, plantations in Mississippi and Alabama, and were a part of connected families throughout North Carolina that were slave owners. And they all worship there at St. Matthew's Episcopal Church in Hillsborough, North Carolina. The other thing that I wanted to share is that I believe that two things can be true at once. More than two things can be true at once. So it is true that Chief Justice Ruffin denounced the Ku Klux Klan. It is true that he was a Unionist, but once he supported secession, he was a part of the Confederate States of America's infrastructure. He was considered to be part of the legal minds that helped to shape that government and to advance that government. He also, we know from correspondence with his neighbors, had an overseer that tortured slaves with salt and pepper in their wounds. We also know that he was a part of the slave trade, the land-based slave trade. So I think that it's important for us to acknowledge that he is considered to be a great legal mind. He has been sanctioned by Harvard. I believe it's his great-grandson, Hamilton, who helped to establish his legacy as a historian. And we know that Hamilton's legacy is also being challenged at UNC right now. And we do know that, that he's been honored in many ways. And I think that being a great legal mind in terms of productivity and respect of your peers does not necessarily mean that you're honorable. And someone who has behaved in terms of beating the woman named Bridget and being aware of the brutal treatment of the enslaved people in his life is not someone that I want to honor, and I need to publicly state that.
Michelle?
Yes.
Michelle? This is
Yes,
Catherine
I'm done.
Beischer. I just wanted to mention in relation to your mention of the Cameron family, we should remember that the reason that we have the great big portrait of Thomas Ruffin is because
Margaret Cameron.
Miss Cameron, his daughter Anne Ruffin Cameron, gave it, and her husband Paul Cameron, who was the richest guy in the state, paid for it. And she gave it in the 1880s. And I think one of the reasons it's been maintained is they had it, and it demanded a large space. And I think it persisted partly out of habit and partly out of recognition of his brilliance. But the circumstances of its donation at that large scale are part of its history, not because a whole lot of Supreme Court justices got together and said, oh, let's see who would be the most important person and who should we put there. It's kind of like having a really giant piece of furniture. A lot of times there's only one place in the house you can put it.
Thank you so much, Commissioner Beischer. I'm also one second, Commissioner Palmer. I have a request. I'm wondering, Commissioner Beischer and Commissioner Newsom-Bass, would you be willing to offer some support around the language of the
I think I'm going to stay out of
final paragraph? Okay, Commissioner Newsom-Bass, I think you offered some support for that.
Yes, I would be willing to. And Commissioner Williams, I think, I don't know if you're
Yes.
willing to as well.
Yes, definitely.
Commissioner Williams.
I'll be willing to.
Okay, so there's a motion and amendment on the table, and I think that we need to take a roll call vote. Where we are with this motion is we have the motion that Commissioner Wichert has shared. We've discussed it. I've read it out loud. We have an amendment that's been added to the motion from Commissioner Williams to work on that final language. We also have the understanding that Commissioner Newsom-Bass is offering some support around that. And so unless someone tells me we are out of compliance with parliamentary procedure, I'd like to entertain a vote on that motion.
What are we voting on?
We're voting on Justice Wichert's motion with the amendment that Commissioner Williams has offered up, that there will be some continued work on that last section around repudiating the legacy of racism in the North Carolina court system and supporting that work of giving us another draft will be Commissioner Williams and Commissioner Newsom-Bass. That's what we're voting on.
I was calling the question, Madam, so don't think you left me out.
I'm sorry, yes, please.
I said I was calling for the question, so don't feel you left me out.
Yes, Commissioner Palmer, please forgive me. I am hamstrung by technology, and so there's aspects
Right.
that I'm just doing the best I can.
I was calling for the question, that's all.
Can I be heard?
Question. Yes, Commissioner Moody.
Yes. I'm not quite sure how we can be asked to vote on the motion when we don't know what the motion is. If the motion is to have two people work on the end of the motion now, that's one thing. But if we're asked to vote on a motion which we don't know what's going to be in the motion, how can we do that?
We actually did that in the last meeting. We said we will vote on it with the understanding that there would be some continued language and that we would approve that language at the next meeting. So that's exactly what we did at the last meeting.
The motion.
So Madam Chair, Madam Chair, point of order, are we voting on the proposed amendment only?
That's
Yes,
a good question.
That's what I called for. The amendment to the motion passed last week that was read by the chair tonight.
Yes, so we're voting on the amendment only.
Yes.
On the amendment only.
Yes.
Thank you.
Yes.
Thank you for that clarification. We are voting on the amendment only.
How many votes does it take to get a majority?
8.
Okay.
Do we still have a quorum, Amanda?
Yes, we do.
Okay, please take a roll call vote. We are voting on the amendment, which will allow Commissioners Williams and Newsom Bass to continue to work with Justice Wichert on the final paragraph or the final section of this motion.
Catherine Beischer,
Yes.
Dr. Paul Bidding, Rachel Blunt,
Yes.
Shelley Lucas Edwards,
Yes.
James Ferguson, Judge Hunter,
No.
Yes.
Moody,
No. Can you hear me? No.
yes, thank you. Commissioner Bass,
Yes.
Dr. Palmer,
Yes.
Steve Stevenson. You want to
He is
type your
voting
vote?
no.
He's voting no.
Yes. He is
Thank you.
voting no based on the type in the chat.
Okay. Dr. Waters,
I'll vote yes on the amendment.
Justice Wichert, I'm sorry,
Justice
Justice
Wichert,
Wichert, I didn't hear you.
I
No.
believe you're muted.
Okay.
Let's see.
I'm sorry. Did he withdraw his motion?
We're voting on the amendment, which Commissioner Williams has made, and Commissioner Justice has voted no.
Madam Chair, can you hear me?
Yes.
Yes.
I'm voting no.
We hear you.
Thank you, Justice Wichert. Dr. Williams,
Yes. Yes.
oh, thank you, Dr. Williams. I'm just counting the votes now. We have 7 yeses, which we need 8 to pass any action.
May I ask, do I understand Judge Richard to vote no on his own amendment?
It's not my amendment, Dr. Palmer. The motion.
Dr. Palmer, we were voting on Commissioner Williams' amendment to work on that language in the lower section of that, the motion. That's what we were voting on.
We're not voting on the main motion?
We voted on the main motion last time, didn't we?
No, we voted on the amendment you brought in for this meeting. And you made a motion out of it, and I seconded it. Now you're voting against your own motion.
No, this is Judge Hunter. The motion we were voting on.
I'm sorry. I was talking to Judge Richard. I was trying to find out why he was voting against his own motion that I second.
No, can you hear me?
I can hear you now.
Okay, I was trying to speak to that motion and I could never get anybody's attention. I think what we're back to is having the motion before us to approve the revisions to what we passed last week. We've already passed all of this with the exception of changing the word portraits to images in the first line of paragraph 2, adding the portion about the Orange County portrait, and adding the language at the end, again, all of which the commission asked me to do last week. If I could, Madam Chair, let me make just very brief other comments. In response to Danny Moody's comments, I want to say he is absolutely right that more than anybody else in the history of the state, he's worked to improve the collection of the portraits and the history of the court. I was his board chair of the Supreme Court Historical Society for many of those years, and I certainly backed his efforts to collect those portraits. I agree with the sentiment that's been expressed that any idea to remove all the portraits is completely outside the court's charge to us. I had one member of the court tell me that just before we all went into confinement, and let me say, this was not Justice Newby, it was one of the Democratic members. He said, surely nobody is suggesting totally removing Ruffin. And now we're suggesting totally removing all the portraits, which goes way beyond what the court has asked us to do. I will just say about the Ruffin portrait, one, I am in sympathy with getting a regular sized portrait there. When I was at the court, when Danny wasn't around to conduct tours, I usually did it, and it was a little hard to explain why that one was so big. But I think it would be very wrong to remove him from the collection simply because he's part of that history. And I will say, I don't consider it venerating him to simply acknowledge the fact that he was part of that history. I think we should know all we can about these people, what they did, about the horrible institution of slavery. I heard Tavolia Glipp, I hope I'm pronouncing her name right, splendid African-American historian at Duke, say once that she was, she knew there were not going to be economic reparations, and she was for knowledge reparations. I'm all for knowledge reparations and knowing all we can about this, but simply having his portrait as part of a collection on the history of the court, I don't think venerates him. The last thing I will say is, I think the Supreme Court asked us to help it, to help them. They were faced with a difficult question. They've got many, many, many other things to worry about right now, more so than usual. They had enough on their plate when I was there. They've got more now with the virus and everything else that's going on. I would like to help them by having this commission come together on what I consider a reasonable compromise that we have crafted together. It is not my work. I have been the draftsman to try to put together what the commission indicated the court wanted to do. So I will close just by saying, I hope we can vote for this motion. I'm not averse to considering other options if we vote this down, but I don't think we should let the report of this commission become the garbage pail for all our frustrations with 200 years of history. I think it needs to be pointed, give the court something specific that it can do, and not put it in too difficult a position as to what kind of statement it adopts about its past. With that, Madam Chair, I would urge passage of the motion that's before us to add the things to what we did last time and go with that as our commission report.
Well, does that change your vote? Because you have purely negated the work you've done and added to the vote from last week by voting against it. We were not voting on whether or not we were going to move all the portraits out of the courtroom. That was not part of the motion. So is that the only thing that made you vote against it?
Dr. Palmer, the motion was to amend the portion regarding a statement from the court on past racism. It was not dealing with the entire motion.
I didn't understand. I understood the last paragraph was the one the ladies wanted and gentlemen wanted to work on. But your no vote negates your whole addition to last week's vote.
No, that's simply not right, Dr. Palmer. I voted to go forward with the motion that was before the court, which is to approve what's there. Now, if this gets voted down, I'm going to do my best to work with everybody to see what we can come up with. I would just say, when you go beyond what I've got there, it gets incredibly complex. I think the court needs something from us on a timely basis. And if at all possible, it helps it for us to be together. And we're not going to get together if we try to deal with all the complexities of 200 years of history.
I'm trying to agree with you, and I'm trying to shorten the work of the commission, but the vote against this whole document tonight doesn't achieve what we are trying to.
I have not voted against the whole document. I voted against a motion to have some amendments made to a portion of it.
Commissioner Richard, I would like to seek clarification as well. So in terms of receiving a future or additional feedback on that language, which I know that Commissioner Newsom-Bass has recognized that that was something that was going to be collective work. Am I hearing that there's not openness to some collective work on that language?
I said right the opposite, Madam Chair.
That's what I thought, but I just wanted to.
Yeah, I am in favor of passing the motion as it is. If that fails, I'm not going to give up on this, and we'll see what we can do.
Understand.
But
Got you.
I think we've got, and let me say, I know they're not. There's only a page or so there. I spent an entire Sunday afternoon trying to figure out the best way to do that hopefully could draw a unanimous vote or at least a majority and get us past this and let us report back to the court, which is what they need from us. I'm for sticking with it as it is, but no, I'm not automatically rejecting anything that somebody else comes up with.
Understood.
I think what we
I think that, yes.
Go ahead.
What I was going to say is I think where we are is that we do need to I do think that we do need some more work on that last statement, and it can, I'm inviting people to communicate. We are in a shared email. We can communicate with each other and share some additional language. I'm also going to ask Amanda if I do think that we need perhaps, I'm going to suggest in terms of moving forward with getting public commentary, I would like to suggest that we have some language that just explains how this commission came to be, what was our charge, and that we're interested in hearing what the public thinks about the future of the portrait. I think if we keep it simple and then we invite emails, I think saying this is what our charge was, this is how we got here, and we would like to know what the public thinks about the future of the portrait, and invite that through email to streamline it. I think that would get us to the next step in terms of receiving public feedback. And I'm wondering if folks feel comfortable with that.
Yeah, Madam Chair, if I understand correctly, we have the motion to amend the current proposal failed. And what we have before us now, what we need to do now is to vote on the proposal, Justice Richards, because that motion has been made and has been seconded. So before we can proceed with any other alternative, we need to vote on that.
Thank you, Commissioner Waters. Thank you. Let's take a roll call vote on the motion.
Wait a minute, I want to make sure I know. Excuse me, this Judge Hunter.
Yes, Judge Hunter.
I want to make sure I know what I'm voting on.
Yes.
As I understand it, the commission last time adopted a proposal, and we are voting on the modest amendments that Justice Richard suggested about to the original document. That's what we're voting on now. We're not voting on anything that we previously approved.
Correct. We are only voting on this new version that we've received that does have that language around the racial history and all of that. Exactly what we've just received for this meeting. That is what we're voting on.
All right. Thank you.
Thank you. And we're going to take a roll call vote now. Amanda, if you can help us.
Of course. Catherine Beischer.
It's tough being at the beginning of the alphabet, I'll tell you. I'll vote for what Judge Richard put together, yes.
Yes. Dr. Paul Bing. Rachel Blunk.
Let me unmute. As it currently stands, I vote no.
Shelley Lucas Edwards.
I would still like some more work on that last paragraph, so I'm going to vote no.
Thank you. James Ferguson. Judge Hunter.
Yes.
Co-Chair Lanier.
Can you hear me?
Yes.
Okay. I too would like some work on the last paragraph. I also would like some language that says that no portraits will be can be seen from behind any of the justices. So I'm also going to vote no.
Thank you. Co-Chair Moody.
Can you hear me?
Yes.
Oh, good. I'm going to vote no because if, as I understand this motion with all its amendments and all the rest of it, it only deals with the rough and painting. If we don't examine anything but the rough and painting, we have failed at our duty.
Thank you, Co-Chair Moody. Commissioner Bass.
I think this is a good start. I think it just needs more work, so I'm going to vote no.
Dr. Palmer.
For all the reasons mentioned, I'd have to vote no, have to withdraw my second.
Thank you, Dr. Palmer. Steve Stevenson.
Steve
Was it-
Stevenson is voting yes in the
Yes.
chat. He is voting yes.
Thank you. Dr. Waters,
No.
Justice Richard,
Yes.
Dr. Williams,
No. It needs more work.
thank you, Dr. Williams. That was 4 yeses. That motion does not pass.
Okay, thank you. I would ask all of us to, first, I would like to take a point of personal privilege, and I would like to thank Justice Richard for all of the work, the sacrifice of time. No one else on this commission has done that, and you have taken us further than we were. I am encouraged by what I'm hearing, that people are saying, I see where we're going, but we need more work, which is further than we were. I do agree with Judge Hunter. This has been a long, slogging process, but I'm going to ask all of us immediately after this meeting to do either send something to Amanda or send something to the whole group in terms of what would work for you. We need to keep moving this forward. I would like to also thank Commissioner Waters for recognizing that we needed to take care of that vote. Thank you for that. I would like to bring up my recommendation again on how to move forward with public commentary. I know that Chief Justice Beasley is particularly interested for us to make sure that we hear from the general public on this, and I would like to streamline this. There's enough complexity in this world right now, and I would like to simplify. And I think that I would entertain I would like to entertain a motion to have Amanda get us started with some draft language that would, and I don't know if I need a motion if we're just going to ask our staff to present some draft language, but I think that if we can get some language that says this is how we came to be, and the reason that we are a commission, and that we are interested in hearing from the public about the future of the Ruffin portrait in the Supreme Court of North Carolina, I think that that is a good start to getting feedback from the public. And I'm wondering
Michelle,
if there are any folks.
may I make a comment on that, please?
Yes, Commissioner Beischer.
It strikes me, I could be corrected on this, obviously, but it seems to me that it might be more useful to wait until we have a proposal before we invite comment.
I tend to think the exact opposite. I tend to like my proposals to reflect the public's perspective, but I hear your perspective as well. Are there other thoughts?
Yes, ma'am.
This is for information. Is there a possibility that the portraits can be located in another site?
I think that, that could be explored. That's something Amanda and I could look into and report back to the commission at our next meeting, if that's something that you would like to know about. And Amanda, we could look, I think, into that, and let's also just get some more information from Orange County. So I think the more information we have, the better.
This is Judge Hunter. My view is, and I'm happy to work with anybody to make improvements, but I made improvements to the last one and worked and put them in a timely manner. As I understand our procedural thing now, the amendments to what we unanimously passed at the last meeting have been rejected, so we have a unanimous statement from the commission that we passed. If we're going to get public comments on anything, I think we would get public comments on that.
Yes, and Judge Hunter, Commissioner Stevenson is in the chat, and he says, have we at least determined this commission stands by the previous vote of removing the large portrait and replacing it with a smaller one, and replace the large portrait with a court seal? And that vote still stands? Yeah, that vote still stands. And he says, I agree we should have a proposal. He agrees with Commissioner Beischer that we should have a proposal before public comment. An open forum would likely be skewed and non-productive. So to your point, Judge Hunter, we could use that original unanimous vote as the language that we seek public feedback on. I would be open to that.
Can I be heard now?
Yes, we can hear you, Commissioner
Okay.
Moody, Co-Chair Moody.
People keep saying this is a unanimous vote. It was not, because I could not vote, but I have recorded
Thank
my
you.
vote today as being no. So it's not
Thank you for that
unanimous.
clarification. It was not unanimous. Thank you. We apologize for that. I apologize. I'll speak for myself. But we did have a vote that did pass. We now have heard yes. Co-Chair Moody would have definitely voted no on that. Thank you, Co-Chair Moody. So to Judge Hunter's point, we have a vote that did pass around replacing the portrait with the court seal, and then also getting a smaller portrait in a different position in the courtroom. That could go forward as the proposal that could go to the public for comment, as well as some context. I think that I need to entertain a motion to see if we can proceed with that as how we want to hear from our public. Would anyone make that motion with me? Is anyone interested in that? Okay, Steve Stevenson has seconded that motion. I think we are. Are we in compliance if we have a second, Justice Witcher, on from Steve Stevenson to take a vote?
It can be your motion, Madam Chair.
Thank you. I've made the motion, and we have an appropriate second, and so now we need a roll call vote. Amanda, if you could take us through that.
Catherine
Would you
Beischer?
reiterate the motion, please?
I sure will, Commissioner Beischer. So the motion is that we will use the motion that passed in the previous meeting regarding replacing the large Ruffin portrait with the court seal of North Carolina and getting a smaller portrait of Ruffin in a different place in the courtroom. We know that that was not a unanimous vote, but we have one nay to that. That we would use that language, Catherine, to seek public feedback on that proposal, along with some context of how we came to be a commission. So context of how we came to be a commission and the proposal based on the motion that passed. So, and then we have a second.
I think we need to be clear that it's the seal of the Supreme Court, not the seal of North Carolina. Is that right?
Thank you. Seal,
yes,
it is the court seal.
Yeah.
Thank you for that point of clarification.
Not the one with the two ladies.
Not the one with the two ladies, the court seal. And then we have a second from Steve Stevenson. And so I think we might be ready for the roll call vote.
Catherine Beischer?
Yes.
Dr. Paul Bidding? Commissioner Blanc?
Yes.
Commissioner Edwards?
Yes.
Commissioner Ferguson? Judge Hunter?
Yes.
Co-Chair Lanier?
Yes.
Co-Chair Moody?
No.
Commissioner Bass?
Yes.
Dr. Palmer?
Yes.
Commissioner Stevenson? And along with his vote, Commissioner Stevenson says, as a recommendation to Amanda, if the proposed change could be computer generated to show the actual change next. Oh, yes, I will provide track changes for everyone. Yes, I can do that. Dr. Waters?
No.
Justice Richard?
Yes.
Dr. Williams?
No.
Thank you. We have 8 yes votes, so that motion does pass.
Thank you, Amanda. I believe we have gotten through the work of our agenda today. I want to thank each and every one of you for your commitment, your time. I know this is an unprecedented time of stress. We are in a pandemic. We are in a racial uprising. We are in a time where we are leaning into our history and thinking about memory in new ways. And I just want to say thank you for everyone's service today. And I recognize that this is very challenging work and demanding work. I'm going to see if Amanda and I can identify a meeting again next month so that we can continue momentum. I know that we have some homework to do in terms of finding out some questions. And I know that we all have homework to do in terms of responding, again, either to Amanda or to the whole group around any additional language that you think would be useful for the motion that Justice Wichert has put forward. With that, I would be glad to entertain a motion to adjourn.
So moved.
I so move.
Okay, do I have a second?
Second.
I heard two so moved, so I take that as a second. Okay, do we have a roll call vote?
Catherine Byer,
Yes.
Dr. Paul Bitting, Rachel Blank,
Yes.
Shelley Lucas Edwards. I believe you're muted, Shelley.
Oh, yes, sorry.
Thank you. James Ferguson, Judge Hunter,
Yes.
Co-Chair Lanier,
Yes.
Co-Chair Moody. It looks like he went ahead and left us. Commissioner Bass,
Yes.
Dr. Palmer,
Madam Chair, for the next agenda, would you please give some thought to what a challenge vote consists of? I vote yes.
Okay, I will give you a call to talk about that more offline. Thank you.
Commissioner Stevenson,
He has an emphatic yes.
Dr. Waters,
Yes.
Justice Wichert,
Yes.
and Dr. Williams.
Yes.
Thank you. That motion carries.
Thank you, everyone. Please stay healthy and safe. Take care.
Thank you.
Thank you, Amanda.
Thank you.
Thank you. Take care.